parliamentary opposition members on the committee where they stand in respect of Clause 5, and that we will go through as many of the revised provisions as possible to move the review work forward. We have moved a lot slower than I would have liked, but I believe the time has been well spent. We are up to date with our records. All the minutes of previous meetings are in place and have been confirmed. And we are now on the very last lap and on the finishing line is in sight, hopefully. Do we have apology for absence from any member?
Yes, Senator Donna Scott Motley is actually traveling overseas.
Thank you. All right, I have no apology for anyone else. Member Scott Motley's apology for absence is noted. We will move to confirmation of the minutes of meeting held on April 20. Beginning with paragraph 1, which records attendance. If there is no correction, we move to paragraph 2. Paragraph 3. Paragraph 4. We go over to page 2. Paragraph 5. There is no correction to paragraph 5. Member,
I hope I'm on the right
Rodriguez.
page. Yes, on that page that is dealing with, I've lost.
That is dealing with?
Minutes.
We're at paragraph 5.
That is dealing with, I'm not calling, it's on page 3, Madam Chair. Or are you still on page
We're taking them. We're taking the minutes paragraph by paragraph. Please hold until we get to your paragraph. All right. If there is no correction to paragraph 5, we move to paragraph 6. Paragraph 7. The paragraph at number 7 commencing, Senator Sinclair inquired. Next paragraph under the heading, penalty for tampering with electronic monitoring devices. We move over to page 3, paragraph under the heading, failure to disclose identity. Move to the paragraph under the heading Clause 5, grant of bail prior to charge, second schedule. Move to paragraph 8, confirmation of minutes of meeting held on March 28, 2023. Paragraph 9, matters arising from the minutes of the meeting held on March 28, 2023. Paragraph 10, confirmation of minutes of the meeting held on March 30, 2023. Member Campbell Rodriguez, was your intervention meant at anything on page 3?
No, it's fine.
Very well.
I'm fine with it. Thanks.
We move to page 4, paragraph 11, under the heading New Business and subhead Revised Bill and Other Matters. We move to paragraph 12, Closing Remarks. Paragraph 13, Dates of next meetings. Paragraph 14, Adjournment. There being no corrections to the minutes, will someone move for confirmation?
I would move, Madam Chair.
Thank you, Member Paulwell. Seconded by?
Seconded.
Seconded by whom?
Member Charles.
Thank you. Matters arising from the minutes, agenda item 6. I should like to say that the meeting of Wednesday, April 26 was cancelled due to a scheduling error. I also want to express my thanks to the committee clerk, Ms. Bailey, for preparing minutes where there are no corrections, and generally for the quality of the minutes prepared for the committee's meeting. All right. The other matter arising from the minutes would be directed to Member Paulwell in respect of the opposition's stance on the pre-charge bail regime. Member Paulwell.
Madam Chairman, you quite rightly laid hands this morning on Member Bunting to do prayers. and I saw you listening intently to the words in the prayers, in the prayer. I will similarly ask Mr. Bunting to speak on our behalf at this time. I will come back to it.
Would you have taken a look at the revised provision of the revised bill? I take it.
The revised clause 5.
Revised clause 5 deals with when and by whom the question of bail is to be decided, setting out the stages. Yes.
Well, I have to start by confessing that I have not looked at the revised clause 5, but unless it very fundamentally differs from the original, I don't believe that the opposition can support this clause. For a number of reasons. First of all, it's way too wide. We believe that the clause as worded would not meet the constitutional requirement of being demonstrably justified in a free and democratic society.
Just pause for me, please.
I'm so sorry, Chairman, for dropping the call just now. I had a problem. Are you hearing me?
Hearing you, Member Paulwell.
Right. I was saying that Member Bunting will be speaking on our behalf at this time.
Yes, I heard.
I had actually started, but the chairman asked me to pause.
Okay, very well.
Yes, please proceed, Member Bunting.
Yes, perhaps I should have prefaced my comments by saying, ideally, the Shadow Minister of Justice, Senator Donna Scott Motley, is the person who would best summarize our position on this. And I believe that we will prepare, if necessary, a minority report reflecting our position on this particular issue. But insofar as I understand it, we cannot support the clause as it's presently drafted. We believe it's way too wide. It covers offenses, the offenses in Part 1 or 2 of the second schedule and punishable with imprisonment, covers, too wide a range of offenses. It really almost changes the presumption of innocence that our system is predicated on. And we don't believe that it would stand challenge because it doesn't meet the standard of being demonstrably justified in a free and democratic society. Before you point out that the leader had on an occasion in response to the insistence by the government on using states of emergency as a routine tool of policing, he had suggested that there could be a very narrow, I don't know if it would be included in the enhanced security measures legislation, which was long mooted, but a very narrow detention without charge provision, which was really something that would be in the nature of emergency powers type legislation. But it was nowhere resembling what we have in Clause 5. It was going to be restricted to a very few offenses, primarily murder and shooting, and the conspiracy charges, the conspiracy type offenses related to that. And it would have been supervised by the court prior to implementation. So in the same way you need a warrant before you do a communications intercept, for example, this would have required a warrant for the extended pre-charge detention. And even in those circumstances, it would have been under constant and close supervision by the court and for a very restricted period of time. So it was very narrowly crafted that in a way that would hopefully be consistent with the Constitution, and in particular, the Charter of Rights, And we don't believe that this clause 5, in the way it is crafted, will be able to stand challenge under these, relative to it being a breach of people's constitutional rights, citizens' constitutional rights. And that, of course, a very summarized position as I understand it, but I believe that Senator Scott Motley would be prepared to draft up the position to be included in the final report as a minority report if necessary.
May I just invite you to indicate which part of the clause as drafted that you specifically take issue with?
Well, I started by saying that I think the application is way too wide. If you just pull up the clause on my computer here, if you look at, it says, we're on reasonable grounds that the defendant has committed an offense listed in part 1 or 2 of the second schedule and punishable with imprisonment. And you go to the second schedule, you would see, the Pradial Larceny Act, for example. We don't believe if somebody is suspected of stealing a goat or a bunch of bananas, etc., that person should be covered by this very extreme clause.
Member Bunting, we have spent, how many months have we been in Joint Select Committee on this bill, Madam Clerk? Right. November, December, January, February, March, April, May. We have spent over half a year in Joint Select Committee reviewing this bill. We have listened to submissions from a wide cross-section of persons, trained and lay, giving their perspectives on the bill. The opposition requested assistance from the Office of the Attorney General on concerns about the constitutionality of the provision. A detailed memorandum was provided by the Office of Attorney General. Having listened and deliberated on the submissions, the decision was taken to revise numerous provisions of the bill. In fact, to do a revised bill. The opposition asked for time to consider their position, and a revised bill was done, and time was allowed for the revised bill to be looked at. And today, having spent all of that time contemplating the deliberations, the committee is being told that the revised bill has not been looked at. And with all the time given, hold a minute. With all the time given.
But don't misquote me. I said I have not been the person on the committee leading this issue. I am not an attorney. I am not.
Hold on, Member Bunting. You can,
Member
Bunting, just hold a minute. Hold a minute.
Overseas and unavoidably absent.
Member
so
Bunting.
That is why she's not
Member
here.
Bunting, please hold a minute.
To address this matter appropriately. But if you insist on ramming it through on a schedule,
Member Bunting,
then I have to give you the shorthand response.
Member Bunting, you really would truthfully say that there is an insistence on ramming anything through? Really, Member Bunting?
Well, if we've been sitting for 6 months,
really, Member Bunting?
You know,
would you,
those of us
would
who are
you
not
think that that is a
full-time,
correct description of the process taken in reviewing the bail bill?
Let me withdraw ramming it through. Let me withdraw.
Really, Member Bunting?
But if you insist on proceeding...
Really? And after all this time, hold on. Both of us shouldn't be speaking at the same time. May I just...
No, I withdrew the term already. Hold on.
So
you don't need to continue down that.
Hold on. I am simply saying that how are the deliberations assisted if after all the time spent and the request for more time by the opposition and a revision has been done today, what is presented on behalf of the opposition members does not take into account the revised provision? How does that assist? But it does appear to me...
We started by saying that the opposition member who is best suited to respond to this was unable to attend today's meeting. Senator Scott Motley was traveling. When this meeting was scheduled, she was already overseas. That is why we're not in a position, or she's not in a position to respond on behalf of the opposition. Mr. Paulwell called me this morning to say that he believes that you will be unwilling to give further time to the opposition. And would I attempt to summarize the position on our behalf? I told him I had grave reservations on that because I am not a lawyer and I'm not in a position to make all the technical legal arguments. So I am making it in a general sense, but I have also said that I believe that Senator Scott Motley will give a response, will draft a response representing the opposition's position and present it in writing to the committee so it can be included in the report as a minority position if necessary.
You think it's reasonable to have expected that with all the time requested and afforded, that and the knowledge that the member from the parliamentary opposition designated to respond would be absent? You think it reasonable to expect that the stance of the opposition would have been provided in writing and on the revised provision? I don't know why the conclusion was drawn that time would not be allowed if it were not asked for this morning. But it does seem clear to me that the initial stance taken by the opposition is the stance taken at this stage, notwithstanding the process that we went through in taking submissions and revising.
But the submissions that were taken supported our initial position.
Member Bunting, it's very clear to me that the opposition is opposing regardless, And so we will proceed. The summary of the stance of the opposition is noted. We will proceed. It does not serve the interest of the people of Jamaica for there not to have been consideration by the opposition of the revised provision. What it tells me is that it doesn't matter what is contained in the revised bill, your stance is to oppose, oppose, oppose. That is what the evidence caused me to conclude. All right, we will move to new business, the review of the revised bill.
Madam Chairman, could I just come in here, because I didn't get from Senator Bunting that there is a full scale opposition against Clause 5. It is rather how to curtail it so that it does not meet a successful constitutional challenge. And I know that there have been deliberations in the committee in relation to containment, but we are being specific that it must relate solely to the issue of shooting, well, two issues, shootings and murder. And so it is not an opposition against the provision, it's not an opposition against the bill. And I just wanted to clarify that. Many of us do feel, and that's why it has been so difficult for us to come to a position. Many of us do feel, especially having regard to some of the submissions, and notwithstanding the AG's position, which we thought about carefully, we felt that the attitude of our courts, especially recently, and in relation to specifically the Charter of Rights, that we do have tremendous hurdles to overcome challenges, and we want to make sure that whatever provisions that we as legislators pass will not be successfully challenged. And that is why it has taken us such time to grapple with these issues. And those supporting the clause, we are restricting it severely.
Member Paulwell, you are an attorney at law. You are an attorney at law. I don't think that it is unreasonable to expect that having revised the bill and having revised the provisions of the bill, that any submission about it being drafted too wide would actually point to the provision to say which part of it you think is cast too widely. But like I say, it is clear the stance is to oppose, oppose, oppose. Member Jackson?
You know, Madam Chair, pardon my delay in joining. I had a little personal emergency to deal with, partly scheduled start that detained me. So I've just joined in the conversation a moment ago. The points made I'm fully aware of. And I was intimating earlier on a moment ago that points raised by Member Paulwell, you know, I fully concur with. And I must say, Madam Chair, we have proffered a position in respect of us, and it is not reasonable nor justifiable to make a comment that the opposition is just opposing. And I say that against the background of the considerable support that the opposition has provided in this review process of the bill overall. And as it relates to Clause 5, where we have very, very strong concerns, which you are aware of, because they have been voiced at this forum on a number of occasions by myself and other members of the opposition. So it's not a new position we're arrived at. As Member Paulwell said, we have been grappling with the issue, and we're grappling with it in the context of trying to give cooperation and full support overall, as we have in other aspects of the bill. So I really don't take kindly to you branding our position and clause 5 as mere opposing. We must agree to respectfully disagree at times. And you yourself have shared that position, and we have done so on many different occasions and many of these committees that we have worked on. So I just want to just clarify that. At the end of the day, we must live with our conscience. I personally must be in the position that I give support to. And other opposition members shares the same disposition.
Thank you, Member Jackson. It is clear to me that the revised provision has not been considered based on what was said. Had the revised provision been considered, I believe any concern remaining would be articulated differently. I think that it is entirely reasonable to have expected a different approach by the opposition to the matter. One of the issues we grappled with during deliberations is the wide casting of an objection without spending the time using the guidance provided by the very court that is feared to say, here is why we believe that this part of the scheme or this part of the clause may have gone too wide. It is entirely reasonable to expect that. Entirely reasonable. And so I maintain that if at the end of the day, having gone through the exercise we have gone through, the objection is being cast practically in the same way that it was cast at the beginning, then it stands to reason that one wonders whether the process of reviewing had any impact on the views. How do you tell members of the public credibly that you have concerns? How do you tell members of the public credibly that after a review, your concerns are practically the same as at the start of the process? How do you convince members of the public that the required time and attention was given to the matter when the revised draft has not even been considered? How do you say, without asking, that the chair wouldn't have granted more time? You haven't asked, but perhaps it is because you know that the time had been given quite generously to enable deliberations among opposition members on the matter. So much time was spent helping members and the public to understand the kind of analysis that is required before you come to the conclusion about whether a particular provision can be said to be demonstrably justified in a free and democratic society. It does appear that all of what we deliberated on just went through one ear and came out through the next.
You know, Madam Chair, Madam, if I may.
Yes.
Madam Chair,
Yes, Member Jackson.
Madam Chair. Yes, I will agree. You have been, as chair, very quite, how should I put, generous in providing for extended time to the opposition. And we have requested it. It is undeniable, but it's unreasonable, unfair and unjust for you to then conclude that even after those extended deliberation, and we don't come to a position that we feel comfortable with, it's going through coming 1 year and coming through the other.
Just be clear, it's the approach I'm speaking about, Member Jackson, not the stance that you take, meaning not whether you support or not. Just be clear about that. I'm saying that the time, so my understanding is that the opposition, as I believe members of the public, wanted an understanding of the process that you go through, the legal process, to determine whether a derogation meets the standards set constitutionally. And so it required going through what the Constitution provides for and how the courts have interpreted the provisions. The various levels, the limbs of analyses. That's all I'm saying, really. That's really what I'm saying. Remember, no, I can't tell the opposition what you must agree with or not agree with. But certainly, if you come to tell me that your view is that, as worded, it is too wide and would not meet the constitutional standard of being demonstrably justified in a free and democratic society, I think it's entirely reasonable to say, let us go through the clause and let us see. I mean, merely pointing to one offense or to say it should be confined to two offenses doesn't answer the question. I thought the request for guidance from the principal legal advisor to the government, and the advice is not an advice to say this is the outcome you want, so this is what it is. It went through a proper analysis, a comparative analysis. Wouldn't it not be reasonable to say, here is where we took issue with the analysis provided, here is where we have concern. That's all I'm saying, you know.
And all that Member Bunting has said is that a written submission is going to happen.
Thank you, Member Paulwell. Madam C, we're moving to review the revised bill. Madam CPC.
Good morning. Madam Chair, I thought that it would be best for the revisions to be considered alongside the report, because that would be the basis on which these revisions were prepared, and it would ensure that the report and the amendments are in sync.
Right. Remember, the report comes at the end of the deliberations. But let us still go through the revised clauses. All right? Let me just clarify something with the clerk. Right. So the clerk is clarifying, Madam CPC, that the report comes at the end and it would not capture what is in the bill itself, but the revisions really are taking into account the deliberations that are reflected in the presentations and the minutes of the meeting. So the report isn't coming at this stage.
Madam Chair?
Yes, Madam
The
CPC.
bill that was circulated contained provisions in bold as well as provisions that were underlined.
Yes.
The underlined provisions represent the provisions that were in the bill that have been reorganized, and the provisions in bold, which are also underlined, reflect the provisions that were revised in accordance with the deliberations of the committee.
All right.
So,
let us start with clause 2.
In the definition of deciding official, in paragraph B, a provision has been added to specify that in the case of a constable, the deciding official shall not be the arresting officer or an officer involved in the investigation of the offense concerned.
And this was revised to streamline which constable would be authorized to make a decision on bail, and not to restrict it to only the category where the defendant had not yet been charged. This is a standardization. So for the purpose of deciding so bail may be granted out of court and in court. Where bail is granted out of court, the deciding officials are justice of the peace and a constable. And the term constable is used as it is used in the Constabulary Force Act. And having taken into account the submissions made, we are expanding the definition around constable to ensure that at whatever stage that the question of bail is to be determined, the constable who does that determination is not the arresting officer or one who has been involved in the investigation of the offense concerned. That is what has been effected, Madam CPC?
Yes, Madam Chair.
Very well. Any comments from members? Right, we go to page 2, clause 3.
In subsection 2, a provision has been added to read, in accordance with this act, so however, that in any case where bail is denied, any order made by the court for the child to be kept in custody shall be in accordance with the Child Care and Protection Act, and that is carrying out the decision that provisions dealing with the custody of children should be in keeping with the provisions of the Child Care and Protection Act.
All right, the clause deals with the application of the act, and the clarification relates to where the question of bail where the defendant is a child, unless otherwise provided in any other act, be determined by a child's court in accordance with this act. Is it necessary to have both so and however, Madam CPC, or can that just be simplified?
So, however, is the usual provision, the usual terminology.
Right, but you know,
proviso.
One of the calls from members of the society is to make the provision easier to read without, of course, compromising the legislative intent. Would it compromise it if the however were taken out, so that in any case?
Well, I don't think that anything is gained by removing the so however. It expresses the fact that it's a qualification. I think when you put it as just a so, it seems to indicate that there's some restriction.
But isn't it the restriction that even though the question of bail is to be determined by a children's court, it also has to be determined in accordance with the provisions of this Act. And that the order made by the court for a child to be kept in custody is to be in accordance with the Child Care and Protection Act, to ensure that all the matters relating to placement of a child, for example, separate and apart from adults, that those are taken into account. So it is the provision is doing three things, I believe. Firstly, it is providing for the question of bail in respect of a child to be determined by the Children's Court. Secondly, that the determination is to be made in accordance with the Bail Act, because it's a question of bail that you're dealing with. And thirdly, that where bail is denied, meaning that the child has to be remanded in custody, then all the provisions relating to keeping a child in custody must be in accordance with the Child Care and Protection Act. Those are the three things that the clarification seeks to achieve.
Yes, Madam Chair, but removing the however just makes it less clear that it's a qualification that's intended, that's all.
All right. Subclause 3.
In subclause 3, the word may was replaced with the word shall.
Right. This reflected. This reflects the submissions made that where the parent consents, then the parent is under a duty to ensure that the child complies with conditions imposed. And this is in contrast with a general provision of sureties being under duty to ensure that the person bailed complies with the conditions. Right? So this reflects the acceptance of recommendations made. We go to clause 5, no?
Clause 5, where there was substantial reorganization.
Just a minute, Madam CPC.
1 second, Chair. There was a decision taken concerning a statement which is present in the law now, which was placed partially in 5, but mostly in 6. And there was a decision that it should be given. It should be earlier in the bill, and it should be a clear statement. And that is a statement of entitlement to bail. And the report bears that, that discussion and decision.
Well, we're not considering a report right now, I'm told. But I disagreed with what was the way it was set out in the draft report, because clause 3 is an application provision, doesn't deal with the entitlement for bail, so it could not be moved there. But clause 4 does deal with the power to grant bail. And then 5, based on how it's reorganized, captures the same wording for each category by the way it's dealt with in the chapeau. So I don't know that what was set out in the report or in the recommendation would hold through based on the reorganization that was made.
My recollection, Madam CPC, is that part of the concern was that there was not a clear statement of the entitlement to bail at the 3 stages that bail is now being, at the 3 stages at which bail may be granted, and also the placement of the provision regarding entitlement to bail. So in structuring the bill, we start with the title, the interpretation section, and the application of it. And
so,
then,
Madam Chair,
yes.
In each case, and we had a discussion about the use of the word shall as opposed to entitled.
Yes.
in each case in clause 5, we have used the word shall.
Right. My recollection, Madam CPC, is that the guidance you provided is that the word entitled need not be used to create an entitlement because it can be provided for through the use of the word shall. Did I get it clearly?
Well, shall is a more emphatic statement.
More emphatic statement.
Also, in each case, based on how the provisions are dealt with, the eligibility for entitlement for bail, if you will, is subject to the considerations that are set out there.
All right. So we know it's a qualified entitlement. Let us proceed to see how Clause 5 has been revised, taking into account the suggestions accepted through the deliberations. Please proceed, Madam CPC.
So it might be more convenient to read the entire clause since there has been substantial reorganization.
Yes.
Clause 5, when and by whom the question of bail is to be decided. 1, the question of bail to a defendant shall be decided in accordance with this act by a deciding official within 48 hours.
Just pause there. So stating the chapeau like this, standardize the time period for the consideration for the decision of the question. Madam CPC?
Yes, because
Right.
based on the decision to consolidate the provisions, when we went through and looked at how it was set out, in each case, the period was the same. So it could be stated in the chapeau to apply
Right.
to all of them.
I'm merely inviting the comments so that those listening will understand why the chapeau is reading as it is now.
Right.
Please proceed.
Within 48 hours, A, after the defendant is arrested or detained on reasonable grounds that the defendant has committed an offense, in any case where such a defendant has not yet been charged because more time is needed to prefer charges. B, after the defendant is taken into custody consequent on being charged with an offense, and that or should be an and. C, after the defendant having been convicted of an offense.
I'm sorry, which should be an and?
The or appearing after paragraph
I see.
B.
Yes.
Yes, because they're not in the alternative. They're, it applies to each case. So, and C, after the defendant having been convicted of an offense, other than an offense listed in part 1 of the schedule, in relation to which the defendant was out of custody on bail immediately prior to the conviction, applies for bail pending the determination of an appeal made by the defendant against the conviction or any sentence imposed in respect of such conviction.
Right.
And there are words in square brackets there based on one of the comments or one of the submissions that was made in relation to the ambit of the rights or the entitlement to appeal after conviction.
Yes, so let's just be clear what it is that we're seeking to achieve with this new formulation. So we're seeking to achieve a standardization of the time within which the question of bail is to be decided in respect of persons who are at various stages of criminal proceedings. And the first stage of criminal proceedings would be after the defendant is arrested or detained on reasonable grounds that an offense has been committed, that the person has committed the offense, but where more time is required for a charge to be preferred. And it was clarified by the AGC that it is that it is not the whether or not a charge has been preferred that would render the arrest or detention lawful, but is whether there is reasonable grounds that the defendant has committed an offense. That has been made clear by the authorities considered and also the specific wording of our Constitution. Your deprivation of liberty is not dependent on whether you are charged. The exception is where there are reasonable grounds that you have committed an offense. And then secondly, so that's the first stage, arrested or detained on reasonable grounds that you have committed an offense. Secondly, taken into custody, charged with an offense, and then you've been convicted of an offense other than those that are listed in the schedule, but you were on bail before the conviction and you have appealed against conviction. The submission, a submission was that we should not just restrict it to an appeal against conviction, but also to sentence, because you may find that the real issue is with the sentence, and then people go through the longer process of appealing conviction. I certainly have no difficulty in accepting the recommendation that it should be expanded to sentence imposed in respect of such conviction. I don't know. I'd be interested in hearing from other committee members. But I think the submission that was made was compelling enough to consider expanding it beyond appeal against conviction to include appeal against the sentence imposed.
Chair, I don't think that was a matter that had been determined.
The presentation, the recommendation came in the presentation of Mr. Jarrett. It's my recollection from the deliberations. And it wasn't a simple recommendation, but it was supported by an argument.
Yes, but I think the committee deferred it.
Yes. Yes.
Oh, well, it's just that
we would be crossing frontiers. We would be crossing frontiers.
Yeah,
yes.
there's a disquiet, because to be honest, we're talking about bail. This person has been convicted now. Depending on the offense for which they are convicted, would you wish for this person to continue to be out on bail while a discussion about the period of their incarceration is to take place? I'm just thinking, you know, in some situations, depending on the nature of the offense, okay, the more like, you know, what they loosely describe as white-collar type offenses, okay, I could see that. But depending on the nature, there are some criminal offenses, for example, where the individual may be appealing sentence, where I don't think that the public would consider it reasonable for this person to continue to be out.
Well, there is no presumption of innocence after conviction.
Yes,
there is no presumption, but the presumption of innocence by itself does not determine whether you can be lawfully detained or deprived of your liberty. That is one of the clarifications that I hope persons tuned into the deliberations would have understood, that the Constitution provides as an exception to the right to liberty deprivation where you have been arrested or detained on suspicion that you have committed an offense. And the cases made it clear that it is not the charging of the person which determines whether the arrest or detention would have been lawful, but whether there were reasonable grounds for suspecting that the person committed an offense. You would see overleaf that in a post-conviction scenario, the deciding official would be either the judge before whom the defendant was convicted or a judge of the Court of Appeal.
Yes, and I wanted to point out that that the chapeau to 5
Yes.
perhaps would be problematic if we include conviction. I think it may be problematic to require or to compel those courts to take that decision within a 48-hour period. That's another point I wanted to make.
Yes. I think, Madam CPC, may I invite a response? Whether putting the chapeau as is at 5-1 to apply to the 3 stages may not be problematic, since presumption of innocence would have been rebutted by the conviction. Presumption of innocence would still apply pre-charge and on charge. But once you have been tried and convicted, there is no longer presumption of innocence. And because of that, it may be more helpful to separate the matter post-conviction.
So, Madam Chair, our instructions were to consolidate the provisions, and that is what we have done. If a decision is taken that a different period is to apply in respect of the post-conviction defendant, then of course we would have to adjust the provision accordingly, and we would split out the reference to the 48 hours, which could appear at the start of.
But would you say that it stands to reason appeal would not be filed on grounds of appeal, would not be filed right away, and so the basis for challenging the conviction or the sentence may not immediately be known? Because if you are on bail and you're convicted, even the conviction changes the scenario. I know in practice there may be, depending on the offense, there may be circumstances where sentence is not handed down immediately and the court may either grant new bail or extend the bail. But I think that is really rare and exceptional, having regard to the type of offenses that we're including, for which the eligibility would exist for consideration of bail post-conviction. I think it makes sense to separate. I invite comments from members, committee members on the matter. Madam CPC, let us consider separating the post-conviction bail from pre-charge and on-charge.
Madam Chair.
Yes.
What is the period that is to apply for the post-conviction? As I had indicated, how we treat with it as mainly what would apply from the chapeau is based on the time periods that are recommended. So I would make the change based on a decision that is made.
All right. Let us go through the revised. Let us go through the entire revised provision.
Chair, just before where in our view, clause 13 could be retained. Clause 13 in the original bill.
Remind me what clause 13. I know it's the post-conviction provision, but just remind me of the terms of it.
Clause 13 is bail after conviction.
Yes.
A defendant who, read it, do you want me to read it? A defendant who, A, is convicted of an offense other than an offense listed in Part 2 of the second schedule, or B, was out of custody on bail immediately prior to the conviction, and C, appeals against the conviction may apply to the judge before whom the defendant was convicted or to a judge of the Court of Appeal for bail pending the determination of the appeal. And then 2, on an appeal under subsection 1, the judge may grant the application if satisfied that exceptional circumstances so warrant and impose such conditions on the grant of bail as the judge considers appropriate. I think clause 13 was
section 13 would have all of the provisions except deliberated on, all of the content deliberated on, except consideration as to whether you would want to expand it to include appeal against sentence. That's the only thing that is not covered there. So it covers the grant of bail in limited circumstances where certain offenses, conviction for certain offenses would be excluded. It covers by whom bail would be granted, and in that case it would be by the court, either the trial court or the appellate court. And it also speaks to the exceptional circumstances that would have to attend on such a defendant in order for bail to be granted.
So, Madam Chair, the only thing that is different here is, or to be decided on, is the 48 hours.
Yes.
Because under 30,
Yes.
no time was specified
Yes.
at all.
Yes.
So if the decision that
Yes.
not to specify the time there, the adjustment would be to move the words 48 hours so that it appears at the beginning of A and at the beginning of B.
Yes, I think that would achieve the legislative intent. And the reason for the differentiation is that it's a completely different scenario post-conviction. While you are deliberating, Madam CPC, let me use the opportunity to welcome to the Parliament the Horace Clark High School. We have 40 children, boys and girls, and teachers. 40 children and 4 teachers. I don't know if it's 36 children and 4 teachers, but I know we have 4 teachers in the mix. Let me welcome you to the Parliament. This is a sitting of a committee of the Parliament, a joint select committee, joint because the committee comprises members from both houses of Parliament. That's the appointed Senate and the elected House of Representatives. And we are reviewing a bill. Bill is a term that we use to describe a law before it is passed. While it is being deliberated on by the Parliament. And this bill relates to the matter of bail. We're actually rewriting the bail law. I hope that you will learn something. Bail relates to the right to liberty, right to freedom of movement, among other things. That is what we are discussing. I am very pleased that more and more schools are bringing students to the Parliament to observe proceedings. The meeting is being held in hybrid form, meaning that some members are attending virtually on the Zoom platform. That is why you're not seeing many people in the Parliament. On what would be to your right, my left, are members of the technical team. They are non-politicians from the Ministries of Justice and Legal and Constitutional Affairs, in particular from the Attorney General's chambers and from the Law Reform Department. I have a view, Mr. Foreman, and how the Office of Attorney General is to be arranged. And in time, it will be so arranged, because I think it reflects the better view, which I believe is what you were hinting at when you asked for clarification. All right? Back to you, Madam CPC. And when we speak of the CPC, I'm speaking of the Chief Parliamentary Counsel. This is a person who drafts the laws. And my name is Marlene Malahoo Fort, Chairman of this committee, Member of Parliament for St. James West Central, serving for the time being as Minister of Legal and Constitutional Affairs. And you should hereby know that the Constitution of Jamaica, which is the supreme law of Jamaica, is being reformed. Madam CPC.
Madam Chair,
Yes.
we have revised the chapeau of subsection 1 so that it reads, the question of bail to a defendant shall be decided in accordance with its act by a deciding official A within 48 hours, and that continues on as read, B within 48 hours, and that continues on as read, and C after the defendant, and that continues on as read. Subsection 2, the deciding official for the purposes of subsection 1A, in a case falling within subsection 1A, shall be 1, a justice of the peace, or 2, a constable at or above the rank of superintendent. B, in a case falling within subsection 1B, 1, except as otherwise provided in subparagraph 2, shall be a constable, a justice of the peace, or a judge. And 2, in the case of an offense within part 2 of the first schedule, shall be a judge. C, in a case falling within subsection 1C, shall be either the judge before whom the defendant was convicted or a judge of the Court of Appeal. 3, where, and I'm adding, where in any case falling within subsection 1A, so where in any case falling within subsection 1A, A, more time than is specified under subsection 1A is required so that an identification parade can be held in relation to the defendant shall, instead of the time specified in subsection 1A, be brought before the judge within 120 hours after the arrest or detention, or B, an identification parade is required to be held in relation to a defendant but has not been held within the time specified in paragraph A, the matter shall be referred to the judge, who shall either 1, specify such further time as shall be allowed for the holding of the identification parade, and upon the expiration of which the defendant shall be brought before the judge for the question of bail to be determined, or 2, make such other order as the judge thinks fit in the circumstances in the absence of the defendant.
Madam CPC, I think the concern was whether the defendant should be brought before the court at all, risking an exposure. So I note the first part of B1 speaks to, it's silent on whether the defendant is to be taken before the court. It merely speaks to referring the matter to the judge. And then the second part speaks to placing the defendant before the court if the extended time has expired. But we just want to be clear that what we're seeking to do is to ensure, so there is an extension of time where the defendant is to be placed on an ID parade. That is already in the law. We want to ensure, if the ID parade is not held for good reason, you may need to have additional time granted. But you want to ensure that there is no risk of exposure. Have we achieved that? It says, make such orders as the judge thinks fit in the circumstances in the absence of the defendant. That's 2. And at 1, specify further time as shall be allowed for the holding of the parade, and upon expiration of which the defendant shall be brought before the judge for the question of bail to be determined, or make such other order as the court thinks fit in the circumstances in the absence of the defendant. Any concern by any member? Any concern by other members of the technical team? There is no risk of misinterpretation when it says the matter shall be referred to the judge, who shall make such order as the judge thinks fit in the circumstances in the absence of the defendant. As clear that there is no risk of exposure in those circumstances. All right. We can move on.
Clause 6, considerations for deciding the question of bail. 1, for the purpose of deciding the question of bail in a case falling under A, Section 5(1)A, the deciding official shall, after considering the matters specified in Section 7(3)A, B, C, D, E, or G, either grant bail to the defendant or refuse the grant of bail to the defendant on the grounds of any of the matters so specified, and B, where bail is not granted to the defendant under paragraph A, a constable shall bring the defendant before a judge of a parish court within 48 hours after the period limited under subsection 1, for the question of bail to be determined having regard to the matters specified in section 7(3)A, B, C, D, E, or G, and 2, in any case where the judge of the parish court denies bail to the defendant, the judge shall specify the period within which the defendant shall be brought back before a judge of the parish court for the question of bail to be reconsidered in accordance with this paragraph.
All right. So what we have done now is to specify the matters to be taken into account in deciding the question of bail where the defendant has not yet been charged. Can we just skip over to 7.3 to be reminded of those matters? The grounds on which it is alleged there is reason to believe the defendant committed the offense, the stage of the investigation so far, and the manner in which investigations so far and the manner in which they have been conducted. Whether further time would enable a charge to be preferred against the defendant, the conduct of the defendant, the reasons given as to why the defendant has not yet been charged, and any other factor that the judge considers relevant. All right? We can proceed.
Right, clause 6.4.
So this pre-charge regime is supervised by the court. Interestingly, opposition said that it didn't think that it would meet the standard because it wasn't. Let me get it correctly. That when the leader of opposition said that he would support a pre-charge detention, it was narrow and that it would be supervised by the court. Well, this provision is a court-supervised provision, but then there is still opposition to it. Proceed.
Minister,
Yes.
It's an issue that was discussed many times, but the new formulation, in our view, continues to appear. It is possible, let me say that, it is possible for it to be interpreted as an additional 48 hours, as crafted, which was not what is intended. When it said in 6.1b, where bail is not granted to the defendant under paragraph A, that one, the way it says within 48 hours after the period limited under subsection 1.
But think about it logically. Think about it logically. You have a certain time in which you would have had to consider the matter. You have to take a number of things into account. You make a decision on it. But if the decision is adverse, it doesn't end there. So you still would need some time to bring the person before the court within the shortest time possible. Because the way it is formulated is for practical administrative consideration without keeping someone in custody for too long. Right. Because you have
that's
to
another
do
2 days, you know.
I'm sorry?
That's another 2 days.
Yes. Yes.
Yeah, may I? I mean, if we're getting to the meat of it, in the redraft, I noticed that the limitation on the types of offenses to which the pre-charge regime operates is not there anymore. Yes, that provision appears to have been removed.
No, it has to stay because it's not every matter that you can put someone within the regime on. Okay. It's targeting a certain level of serious offenses.
Right.
So you can't just pull in someone and put them under conditions for any and every offense.
Okay.
The policy intent relates to certain category of offenses that the data shows are causing problems on the crime front.
Right. Okay, so that needs to be tweaked. But I raised that to say that my further understanding of the intention, as you say, to have that regime limited to specific types of offenses, and that the specific type of offenses were the same ones for which in the post-charge regime a determination can only be made by a judge, so the murder, firearms offenses, etc. If that's the case, and this arises from the same considerations I raised the last time, so I've had time to think about it a little bit. Perhaps the pre-charge regime should therefore mirror the regime that obtains the pre-charge regime should mirror the procedures that apply in relation to the offenses for which post-charge bail can only be considered by the judge. And if that's the case, two consequences that I think would emerge in terms of crafting the bill. One would be that the triggering event, the arrest and detention on reasonable suspicion of having committed an offense, the time frame between that triggering event and bringing the person before the court would be 48 hours. And the decision to grant bail or not would immediately be considered by a judge. And that would mean not having a justice of the peace or constable above the rank of superintendent make an assessment of whether to grant bail in the pre-charge regime. So I'm raising the question of whether the pre-charge regime should, one, have a 48-hour period between arrest and detention and being brought before a judge, and two, that the judge is the one who makes the decision to grant bail or not, so that it mirrors
the intention always is to take steps that can be taken outside of the court without causing any prejudice. So as a matter of policy, bail can be granted out of court and it can be granted in court. There are limitations on the grant of bail out of court, meaning that there are some matters that you want to place before the court, having regard to the seriousness of the offense and related matters. So the intention is not immediately to escalate a matter directly before the court, but to accept for certain type of offenses. The question was whether, since a person had not yet been charged, whether you would make that distinction in the pre-charge scenario by having a first consideration out of court before taking it to court. Because something changes on a charge, it's moved from reasonable suspicion to formal accusation. So that is the progression. And the Constitution, I think many people seem not to get it, that the Constitution permits a deprivation of liberty on reasonable suspicion that you have committed an offense. There are a number of stages in the proceedings along the way, but the initial threshold is reasonable suspicion on that you have committed an offense. That's the immediate, and you clarified that in your presentation. So we don't want to formulate the matter in a way that is equating the deprivation or premising it on a charge, because that is not what the Constitution provides for, and the courts have interpreted it and clarified it also.
I mean, there's a distinction between what you can do in law and what you think might be best to do, having regard to the policy objective.
Right.
So my comment came from a reflection on what I
No,
understood the policy
I
objective
hear you.
to be.
I mean, we're thinking it through.
And,
Yes.
in light of what was said earlier from other members of the committee, there might be some synergies that might arise if the system is crafted in that way.
Well,
Madam Chairman?
it's a rights-based objection, and I would think that a more favorable treatment is being provided for if consideration is given out of court, if the argument is taken to its logical conclusion. Right? The premise of the objection and the opposition to it is rights-based, so that it seemed to me that if your concern is about the rights, then you would want to ensure at the earliest opportunity that the right is impaired as least as possible at the earliest opportunity. I'm just saying that's why I'm extremely disappointed that we didn't get a more reasoned opposition to the regime, especially as redrafted since the revised provision was made available with sufficient time to go through it. Member Jackson, you have your hand up. Member Jackson?
Chairman.
Oh, Member Paulwell? Yes.
Yes, I'm so sorry. As you know, we have Parliament soon, so I'm actually driving. But that discussion just now is so important to us, because I remember in our own deliberations, those issues did come up, and you will see them in the written submission. I just wanted to be clear in terms of the offences. I don't recall that there was any diminution of the list of offences that are applicable in terms of the pre-charge. Was that revised? If you could
sorry, if I might, members chair, it's an omission on my part. It was an error. It should have specified that it's only applicable in respect of the offences listed in part 1 or 2 of the first schedule. Sorry.
Okay, so those offences are maintained in this revised bill to date.
Yes.
Maybe part 2, because part 1 deals with the offences for which application for bail should not be made after conviction. Part 2 deals with offences in respect of which bail to a defendant charged with an offence may only be granted by a judge. As I said, my sort of understanding of the policy intent was that these types of offences for which bail can only be granted by a judge reflect the type of seriousness for which the pre-charge regime it is thought would assist in investigation of crime.
Yes, and I believe that your submission just now was trying to grapple with the major concerns that we have, and the chairman has berated us for not putting it in greater detail. But I believe what you have just said is worthy of active contemplation. We certainly will take it back as we prepare our submission, because I perceive a solution therein.
Member Paulwell, let me make it very clear that it is unfortunate that your side has concluded on the provision without seemingly look at the revision, or even say, let us look at what we have concerns with so that we can see what amendments have to be made. It's very clear to me, based on your handing over of the matter to your colleague Bunting, that certainly up to this point. But that's what he said, Member Paul. He began by saying that the opposition cannot support the regime.
But we are supporting it to a certain extent. We are supporting it to
so
a certain extent.
So you get your news headlines, because clearly that must have been what it was targeted at.
No. To be fair...
Pardon my cynicism. I can't help but being cynical about it. Because...
No, but the very issues that are now being raised on the floor are those issues that we have been grappling with for weeks.
But I wouldn't know, Member Paul, I wouldn't know if you ask for time to consider, to come back to tell the committee what it is, and the time was granted not once or twice, but more than 3 times for further consideration, and still you come back. Come on, man.
To be fair, Chairman, to be fair, this matter is not easy.
6 months of deliberation, 6 months.
But we've had the court ruled against processes by this government, and we are all a part of it. So if we are concerned about...
But the courts have also clarified issues and clarified the approach when you are determining whether the test of derogation, the standard has been met. So it cannot be unreasonable to expect more from the opposition after we went through the process that we have gone through, having during the process benefited from clarifications from our highest court.
Yes, but I'm so
Come
happy
on,
to
man.
that
No, man.
all of that. We are still in a negotiation at this stage.
So you're changing the stance of the opposition now. Hold on, let me just clarify.
I'm not changing the stance.
You're not changing the stance.
We're benefiting now from the further discussion that we are hearing and some of the changes that are being contemplated even at this stage.
But Member Paulwell, with all due respect, that doesn't make sense, because it's not like the revised provision was not given to the opposition members. With all due respect.
Madam Chairman,
yes?
I'm sorry I didn't hear that last comment. But
I
all
am
I'm
saying, Member Paulwell,
is to ensure that at this stage, when further contemplation is being given, we try to arrive at the best position in terms of the constitution of this law. That is my major focus and concern at this time.
I hear you, because I am also trying to understand. The initial objection was that you can't deny a person their liberty if they have not been charged. You can't just arrest and lock up. We went through and we clarified both the language, the letter, and spirit of the Constitution, and also how it has been pronounced on. We went through the cases from other jurisdictions on the issue. But you come this morning and you say, we can't support it. Your side didn't start by saying, when I ask if the new provision has been looked at, the answer was in effect no.
But Chairman, if we say to you that we would support it if it were restricted to murders and shootings, what does that mean, Chairman?
But Member,
it means that we should negotiate.
Member Phillips, it's not murder and shooting alone. There are a set of other offenses that support murder and shooting. So you can't pluck out the murder and shooting alone without looking at what finances the gun running, the shooting, and the murder. So if you're telling me and telling the committee why only 2, wouldn't it be reasonable to say how it is that you would want to separate those out, standing on their own, when the country in which we live has a particular kind of problem, and the financing of illegal guns to get to someone to get to the stage where you can shoot it. The issues around murder. How then do you logically and reasonably separate out the other offenses that the data shows are part and parcel of the mayhem in the society? I'm just trying to understand. And then you tell me that you're not revising the position, but they are all inconsistent. But pardon me, my little brain works in a certain way. Are you near here now, since you're on your way? No, it's just clear that you...
I'm just going to pass you, Kingston, so I'm not there as yet.
Okay.
But I would like to suggest, perhaps after this meeting, for you and us, without the cameras, try to go through...
Do you recall that I offered that, Member Paulwell? I offered that.
I really don't recall that, but you know, your memory is probably better than mine at this time.
Specifically, I said, let me know if there is anything after the written legal memorandum from the chambers was provided. It is for these and other reasons why it's hard to convince the people of Jamaica that their affairs are being treated with a level of seriousness that is required.
Well,
we began talking about getting things done as, you know, as expeditiously, without compromising the quality of the work. It's a short bill. It's not even a new area. We're rewriting an existing law. 6 months, half a year.
But Chairman, with the greatest respect, it is these short bills that give us the most trouble. But,
Member Paulwell, I am concluding that the time has not been used well to review it based on what was put out by the opposition.
And you're entirely entitled to your view. I am saying to you that we have spent time on this committee going through many submissions. We have listened to so many persons come to this committee who have indicated strong, in fact, stronger opposition than we to date have submitted. And I really believe that it is belittling what we have done so far, everybody, plus our own contemplation on these issues outside of the committee meeting, to say that what we presented to you doesn't make sense. I think...
No, I didn't say that. I'm saying that the reason... Well, clearly Member Bunting wanted his headline, so he has gotten it. Because what you're saying to me is not consistent with what was presented. What you're now saying to me is that you're prepared to look through the revised provision and for us to reason it through. That is not what Member Bunting said on behalf of the parliamentary opposition, respectfully.
To be clear, the opposition's position was as stated earlier today by Member Bunting. In the discussions just now, especially just now, I am hearing things that resonate. And they resonate because they were contemplated in our own internal discussions that to date did not reflect amendments in the bill or revised position. And I think that is encouraging. And because we want to be fruitful and useful, I would love for us to continue along this line to see how we can work, having agreed that the thing is going to be supervised by judges, and to insist on that supervision. Then we look at the timelines.
But that was always in the law, Member Paulwell. That was always in the law.
Yes.
That was always in the law. That's why I keep saying, let us look on what is actually written. That was in it first, and it is also in it today. But you can't tell me that you're serious when the revised text has not been analyzed.
Well,
I am left to conclude is in your own time, whenever it happens, without any sense of urgency to dealing with the matter.
All right, so it appears as if you really want to see our written submission before any further discussion. Now, we will do so.
I'm disappointed. I really am very disappointed because Time was asked for, the expectation that having asked for the time, not once, not twice, but over 3 times, and having been afforded that time, that we would come today with something.
Probably I should not have cut the conversation that you were having just now, because it proves the point that a lot of things are still unresolved. But I close my submissions at this point.
All right, come safely. Come
Thank
safely.
you, Madam.
Yes, come safely. Still leaves me very disappointed with the approach taken. Can't ask you to support what you're not willing to support. But if you tell me you're not supporting for a particular reason, set out the reason to the standard required in law.
I'm driving myself and I have to be hands-free, so.
Come safely. I hope you're not using the phone while you're driving. I hope that it's through the Bluetooth.
Hands-free.
Yes.
But, you know, you still have to pay attention to the traffic.
Yes. Yes. So take care to comply with the law for your own safety and the safety of others.
Thank you, Chairman.
Right. All right. So the CPC said that it was an omission on her part because the policy intent in respect of the pre-charge regime is to deal with, is in relation to the more serious offenses the data show impacting the society.
Yes, Madam Chair. So the 5.1A should have refers to an offense listed in Part 1 or 2 of the first schedule.
Sorry, Madam CPC, just tell me what it should say.
5.1A should read, within 48 hours after the defendant is arrested or detained on reasonable grounds that the defendant has committed an offense listed in Part 1 or 2 of the first schedule. In any case where
so it would be listed in the first schedule?
In Part 1 or 2 of the first schedule.
But that seemed a little...
that's what the original provision
Hold on.
has.
Yes. Yeah. Remember, we are clarifying. It's not just whether the original provision said it, but we took time to determine the kind of offenses that are kind of criminal conduct that are wreaking havoc on the society. So we know it's the murder that's at a 1 in both parts, 1 and 2. So we know it's the gun offenses on the prohibition side of the law, the possession, stockpiling, trafficking, the manufacturing, the dealing, the diversion.
Madam Chair, has the redrafted position 5 reduced the range of offenses outlined in Part 1 and 2 of the schedule in the original bill? Could you just identify that? Because when I looked at the revised Clause 5, it didn't appear to me to be restricting or narrowing that range of offenses.
Clause Part 1 of the first schedule in the revised bill speaks to murder. That's at item 1. Item 2 deals with the gun offenses. Item 3 deal with the gang offenses. An issue was raised in respect of the matter listed at item 4 on the offense of failure to disclose identity, not because it wasn't understood the importance of the matter, but because of how the offense itself was treated as a minor offense under the Zozo law. And the other provision deals with the lotto scamming. And they are put together because of how the data show the pattern. So the lotto scamming provides financing. The gangs get together and they dominate the scene with the guns and murder, and also the lotto scamming. So that's what the data revealed. Those are the only offenses in part 1. Guns, gangs, lotto scamming, and the murder. And then at part 2, right, we have treason, felony. Standardly, those offenses are treated in a particular way. Murder. Then we have arson of a dwelling house, because the data showed a pattern in that regard. We have matters of predial larceny. The data is showing that there is a level of organization to the predial larceny, right? To provide food and sustenance for the gangs who are scamming and thing. There is a link. It's not just a man walk across and steal a pineapple, but there is a seriousness to it, linking the whole pattern of criminality. That has to be taken into account. And then we have matters relating to murder again. And then we go down to 6, matters relating to drugs, which the data show is part of the trafficking, because you have drugs for guns and you have financing of the guns and other things through the drug trade. And then you have the trafficking in person, and you have trafficking in children, and the sexual offenses. So you also have matters under the Terrorism Prevention Act, matters in relation to malicious injuries to property, matters relating to lotto scamming, matters relating to anti-gang, and matters relating to the firearms. Those are there. So, sorry. Yes, before I come to you.
Okay.
Those are the Member Bunting.
Yes, so coming back to, I understand, Chair, that you can have predicate offenses under, say, the Predial Larceny Act or the Malicious Injury to Property Act that may tie back to organized crime or criminal gangs. But it won't necessarily be so, and I'm guessing that in many cases it will not be so. So it still speaks to the breadth, the concern about the wide range of persons it would touch upon. And while I appreciate that it might be somewhat narrowed, but in my view, and since this meeting has started, I've looked back on the offenses in part 2.
Did you read the revised bill?
I have read the revised bill.
You have not, okay.
I have read it. I have read it, but what I could not put my hand on this morning was the opinion of the AG's department. Since
you were not present when we went through that. Were you present?
No, I was.
I
unfortunately missed that meeting.
Right.
But just on your even, and I'm also driving, and I apologize if my signal, or I'm being driven, but I apologize if my signal goes in and out. But the breadth of offenses there, without being tied, say, to organized crime, or whereas, for example, the anti-gang legislation speaks to some of these offenses being done in support of a criminal organization. But if we don't constrain it, then it comes back to the case. It doesn't exclude, let me say, the case of the man who may be suspected of stealing a bunch of bananas or the pineapples. So coming back to Minister Paulwell's intervention, perhaps we could look more closely at how we narrow the application of Clause 5.
When you look at what is actually provided for, you would see that the matters are not at large, really, because in determining the question, you are looking at those matters set out at clause 7. The grounds on which it is alleged, there is reason to believe that the offense was committed. The stage of the investigation, including the manner in which it has been conducted, whether further time would enable a charge to be preferred, conduct of the defendant, reason given as to why the defendant has not been charged, and any factor that the judge believes to be relevant. So that you would recall when you were in government that there was what appeared to have been a minor offense that was critical to the anti-gang work, and that was the lesser offense of receiving stolen property. If you treat offenses just by how they appear on the surface, without being guided by the data, how the conduct leading to the offense weaves into the level of high criminality, we would be running the risk of not addressing the real problem. So it's not true to say that everyone who is alleged to have committed those offenses can be drawn in or will be drawn in. And that's why the regime is set in a way that it targets defendants who operate at a certain level and are on the radar of the police high command at a particular level. The entire bill has to be read to understand the overall scheme. And the clause itself has to be read in its entirety, including the clauses that are referred to get a thorough understanding of it. And then the issues about the constitutionality of it need to be specified. So I still don't know, after we went through the process, what it is that the opposition is saying it finds to be unconstitutional. Because it cannot be that you include an offense which is an offense on the book that makes it unconstitutional. No. It cannot be that because it is a lesser offense, it makes it unconstitutional. No. It cannot be that it is because it is an offense that you may not want to include that makes it unconstitutional. That may go to whether you support it or not, but that doesn't make it unconstitutional. It cannot be that if I were dealing with it, I would deal with it in a different way, with a different policy approach. That doesn't make it unconstitutional. So I am trying to understand what exactly is being alleged after we went through the process to be unconstitutional. Because it's not what you feel about whether something is demonstrably justified. The court has guided us on the approach to take in arriving at a conclusion on that matter. So I'm still trying to wrap my mind around what specifically. The breadth of the offenses does not make it unconstitutional. It may go to another reason for a lack of support or opposing it. So it would help the process if the bane of contention is the constitutionality or the perceived unconstitutionality of the provision, that I hear exactly what it is. Because telling me you have a concern about which offense is included does not make it unconstitutional. Member Bunting, are you still there? Member Bunting, are you still Member Bunting, are you still there? Telling me that you have an issue with which offense is included does not make the concern, does not rise to the level of making the provision unconstitutional. There must be another reason for it. Madam CPC?
Chair, before you go to
Madam Chair.
Just once. The offenses that are in Part 1 and Part 2 are not different, you know, Chair. They're not. So I just wanted to point that out. So the net effect, it would
Part
be,
1 is a subset of Part 2.
yes, but the net effect is that the justice of the peace or the constable can only consider bail in the case of the offenses that are not in Part 1 and Part 2 of the schedule. Because the offenses in Part 1 can only be considered by a judge. Offenses in Part 2 can only be considered by a judge. So it's anything that's not in the schedule. That is what would apply in the case of pre-charge bail. And I think that that is okay.
It's not clear though from the draft.
And you think that that is?
That is fine. That's okay.
We do such an injustice to the people of Jamaica when we come here not prepared and we make statements that we can't support. We really do an injustice to the people, you know. Right. Madam CPC.
Yes, Madam Chair, I just realized what has been troubling me about the provision and the tie-in with the listing of offenses in Part 1 and 2 for what is in Clause 5(1)(a). So if a defendant is arrested,
You ponder, let me share my thoughts. Mr. Foreman, what a pity that the stellar work you did to go through the cases and the provision and the Constitution didn't persuade anyone on the opposition side. Do not take it to heart. Madam CPC.
yes, Madam Chair, I was querying whether there was a time frame for the persons who were arrested or detained for an offense that is not listed in Part 1 or 2 of the schedule.
Let's go back to policy intent. Let us go back to policy intent. There is a certain kind of criminal conduct in the society involving murder, gun running, lotto scamming, gangsterism, terrorism, destruction of property, raping, sexually abusing people, leaving them in a state where they are in fear of their lives. Reality of the society is that serious offenses are committed. People who witness the offenses are not always immediately available to facilitate completion of the investigation in as timely a manner that we would like. And those people who are committing the horrible, heinous criminal activities may need to be monitored. Once the constitutional threshold is crossed, that there is reasonable suspicion for the person that the person has committed the offense, that person can be deprived of his liberty. And the Constitution didn't even specify major or minor offense. It speaks to an offense. And we are in this country trying to deal with the rampant criminality and high murder and gun running rate and lotto scamming and everything that is financing the criminal activities. The offenses listed are informed by data. What are we seeking to do? That if the intelligence reveals that you have committed certain type of offense, it passes the constitutional threshold, but for good reason, more time is required to bring the charge. In appropriate cases, you bring in those defendants and you have the court assist in monitoring until you're able to charge. That's what we're seeking to do, so that these people are not at large. These criminals are not at large. Simply because the witnesses may be reluctant to come forward immediately, or because time is required for relevant parts of the evidence to be obtained either through telecoms or any of the technology that is available. This doesn't involve any arbitrariness. That's what we're seeking to do. It is targeting people who have committed offenses and are at the early stage of criminal proceedings. Early stage. So they do not remain at large to do further harm and to pervert the course of justice. As part of the safeguard, we have restricted the type of criminal conduct being targeted. There was no need to restrict it constitutionally, but it is because we are targeting people who are involved in certain criminal misconduct or criminal conduct. Member Jackson, are you still with us? Member Jackson?
Yes, Chairman.
Yes.
I'm very much here and I listen to you.
Right. So you are of the view that including a particular offense as opposed to another makes the provision unconstitutional?
Madam Chair, and the matter, the point has been made. You have a different position and you're entitled to that.
I'm just seeking clarification.
No,
Member Jackson.
Madam Chair, with all due respect, We had extensive discussion on it earlier on. It doesn't comport with what you wanted or what you expected. So a cross-examination won't bring you there.
No. I'm genuinely seeking to understand. So I understand that the position may be for other reasons. That's what I'm seeking to understand, you know.
You know, you might be able to come to a definitive position much sooner than others with what is available to you, based on your own contentment with what you have. But because you are there doesn't mean that everybody else must be there or at the same time. You know, Madam Chair, you know what I find a bit disingenuous?
Tell me.
It has been on the drawing board before it reached to the committee level for almost 3 years. 3 years. When we were told that there are many aspects of it that are being deliberated on and pursued. Over 3 years. So against that background, Madam Chair.
So when it comes to the drawing board, we must take another 3 years.
No. Against that background, you are not going to whip anybody into conformity with the position that you have arrived at.
No, Member Jackson, no.
We have made it clear we have certain issues that we have, I personally.
Right. And I am. What would be the point if not to ask to see if clarification can be provided? If you don't ask, you won't know.
It can't be on this occasion, Madam Chair.
So that's a real issue, not today, but some other day. I'm honestly trying to understand.
No, Madam Chair, just accept what has been presented to you. And I also accept that is not acceptable to you.
Member Jackson, my contention is not...
I respect you're not being contented with it.
No, let me clarify. My contention is not with the stance taken by the opposition per se. Disappointed as I may be, my contention is with the reason given, so that if the reason is truly what has been stated, then to my mind, we can reason it out. But if in reasoning it out, hold on, if in reasoning it out, the reason doesn't convince, then we leave it at that. That's all. But my approach is to understand. My approach is to try to understand. If the allegation is one of unconstitutionality, then there is an approach which guides us. The approach that the court has provided to guide us. That's all I'm saying. That's where I'm coming from. That's all. No more, no less.
Well, as much as I'm saying, Madam Speaker, I have seen quite often, I wouldn't say quite often, but from time to time, position advance based on what information, what understanding, what level of comfort one may have with a particular point, and they either delayed or varied over time. All we are saying that our comfort level with what is before us doesn't lead us to say ditto, as you would want us to do. That's simply it. I understand also that you want to have a conclusion with a concurrence.
No.
I understand.
Well, the truth is that...
There's a legal argument, there's a legal point provided by the AG's department. You know, we respect the position.
The truth is that it's not necessarily that I want concurrence. I'm seeking understanding.
Well, I am saying to you, Madam Chair, and I think I speak for the rest of my colleagues and the opposition.
Right.
At this time, we have no more to say. At this time. And you in particular, at some point in time, I've made long deference.
Well, if I understand, in the own sweet time, when it happens, it happens. That's what I am getting. No, that too. Is another point.
No, Madam Chair.
Yes.
Your choice of words are disingenuous.
There is nothing disingenuous about
3 years,
it.
I could have said it in your own time. That's how long you took to come back.
Member Jackson, we have time boundaries within which we are operating. And if the stance of the parliamentary opposition is that it respects no time boundary, I didn't get to that. Meaning, having asked for time to today, having asked and asked and asked, there has to come a time when, there has to come time. I am not. Let us not argue further. You've said not today. You have said not today.
You don't.
Member Jackson.
Madam Chair, with all due respect, you don't have the moral authority to talk about not respecting time-bound stipulation, because this particular bill, I happen to know, not 3 years. It's almost 5 years that this has been in gestation while you are contemplating many legal points.
Member Jackson.
That is the background and history. So I don't want you to come and make this kind
Member Jackson.
about us.
The responsibilities are different. The responsibilities are different, and I think you do know that. The responsibility for government, of government side in the parliament, is very different from the responsibility of the opposition side.
We know that.
The responsibility of a minister is different from the responsibility of a shadow minister or a spokesperson.
No, you're not.
With all due respect, hold on. With all due respect, the constitutional responsibility wouldn't fall to you. And it wouldn't fall to me if I were in opposition either. Other responsibilities may fall. So to say that because a matter has been deliberated on in the policy stage for a certain time means that once it is formulated and presented, then it should be equally deliberated on for as much time. It's very clear. So if your argument is that it took 3 years to deliberate on the policy to work it out because it's breaking new ground, then you need another 3 years. What you are in effect saying is that not in this parliament lifetime. That's what you're in effect saying.
No, you are so disingenuous, it's very discouraging. I don't need you, Madam Chair, to tell me
what else could I conclude if that is the analogy you've raised? Let's not trade.
Into your own conclusion.
Member Jackson, let us not
go any further with
go
this.
there.
And I have no more to say.
Let us not go there. Let us really not go there. I've made no accusation.
I hope that you never went there.
Have made no accusation about you. I am simply trying to understand the reasons given for the opposition to the regime. That's all I'm seeking to understand. And I maintain at the end of the day, if the concern is about which offense the regime applies to, then with all due respect, that concern does not rise to the level of constitutionality. That's the simple point. The other point is that if you have requested and were granted time for consideration, and today no further time was requested, but you come to tell me not today, then what can I conclude? If not today, when? And you would categorize that as disingenuous? Seriously? All right. We will wrap the deliberations today. If the opposition is not willing to support, just say that. We will take the bill, we will continue the revision, we take the report to the House, we'll vote on it. Unlike many others, I do not fear a court being asked to pronounce on the constitutionality of any provision. On this bill, it wouldn't be, because it has not been thought out and properly deliberated on. I don't quiver when I hear that the court is doing what the court is supposed to do. That is the work of the judicial branch of government. It interprets and it determines through its interpretation consistency with the Constitution. That is its work. The Parliament has its own work to do. So in this case, if after all of the deliberations, the court were to say something, what must we do? The court comes to a matter from a different angle. The latest decision from the Privy Council speaks to a margin of appreciation that the judicial branch is to give to the legislative branch. What I find disingenuous is a stance not to support regardless of any explanation provided. That is what I find disingenuous, if we are to go there. But time is upon us. Let us pause deliberation on the review of the revised bill and move to item 8 of any other business. Is there any other business that any member of the committee wishes to raise? No other business? Then we will look on right. We look on the next available dates to bring the review of the bill to conclusion in the committee and to report back to the Parliament soonest. The morning of Thursday is not available. It's just checking with the committee clerk for dates. All right. Having regard to the parliamentary calendar, and the competition for, is everyone we had initially canvassed Thursday, but the morning of Thursday is already taken. So we have 2 dates that we are looking on. That's Wednesday the 24th. Thursday of this week in the afternoon and Wednesday the 24th. Mr. Jackson, Member Jackson, would your side benefit for the longer time for the next meeting to the 24th?
Yes, Chairman.
That's Wednesday the 24th.
Sorry. Hello?
Parliament. Oh,
Hello?
we have Parliament on that day, so it would be morning. Right. That would be Wednesday, May 24 at 10 a.m., and it would be for the morning session. May I ask Member Jackson for the written position of the parliamentary opposition on the matter in advance of that date? Is that a commitment you can give?
I will work towards that. I will confer with my colleagues, but I work towards that.
Right, and you will appreciate that if the stance is a no support stance, then getting it ahead of time would not assist. But if the concerns relate to what is in the bill, and there are suggestions, I would ask that those be set out.
We
clearly.
will provide.
Right. And if it is a matter of preference as opposed to a matter of concern about the constitutionality, I would also ask that that be specified.
Duly noted.
Because a preference for a different policy option does not make a matter unconstitutional of and by itself. So that's all I'm asking for from the parliamentary opposition. If you allege unconstitutionality, please assist by indicating why. If it is a matter of another preference, then please clearly indicate the reason. And may I ask that the committee, since the matter has already been deliberated on and it was just a matter of another member of the committee making the presentation, if that continues to hold, then we could ask that we get the written position of the opposition by Tuesday the 17th. By Wednesday the 17th, or Tuesday the 16th rather, by Tuesday the 16th. Please send to the clerk, and the clerk will distribute to the committee members. That's okay, Member Jackson?
No, as I said before, Chairman, do note it and we work towards the requested timeline.
So the date and time of the next meeting would be Wednesday, May 24 at 10 a.m. Wednesday, May 24. Will someone move for the adjournment? Seconded by?
I can second it if so.
Thank you, Member Charles. Meeting is adjourned at 12:39.
It's Tuesday, May 9. In the headlines, Jamaicans urged not to use unfinished roads. In business news, NCB Insurance Agency launches online pensions portal. Regionally, direct flights between Barbados and Tobago. Internationally, Chicago struggles to house a migrant influx bust from Texas. And in sports, Olympian Shelly-Ann Fraser-Price is the 2020